on pages 26
Okay,
to
guys.
28 of the judgment.
Of all the arguments we heard on the hearing in front of the Chief Justice, I think main the two main arguments were done by the attorney
Paragraph 106, Your
for
Honor.
the chairman,
Paragraph
Justice retired Justice Claudette Singh,
106.
and the
The
attorney
court
for
made this specific
the
finding. This
CEO
very issue, Your Honor, my friends
Lowenfield
have not
by
raised before this
attorney
court again.
Boston,
When
and
the
for
Court of
the
Appeal has already
GECOM
pronounced the
chair
verdict.
it was
Secondly, there is no appeal. There was
counsel Miss
no
Light.
appeal from Unity
So
nor to the CCJ.
let's first listen to
And
Miss
as a
Light, her
consequence, Your
argument, then we're
Honor,
going to see what Mr.
the
Boston
hierarchy of
counters.
courts
Okay?
dictate that your court is bound by the majority decision of the Court of Appeal. I therefore ask, Your Honor, why we are here again. It's a rhetorical question.
Now, Ms. Kite's first point of why are we here, because this was never challenged to the CCJ in the Ulita Moore, and it's the same thing being brought back. So it seems irrelevant and it should be dismissed right here, but she's just trying to make a point. But let's continue to listen.
Section 22. When there is a specific ruling that Section 22 can be best, the constitutionality of Section 22 can be best addressed during an election petition. And Your Honor, I find that that is the basis of most of the arguments proffered by Senior Jeremy. Those are the constitutionality of Section 22 is the platform upon which he bases all of his arguments. And Your Honor, that section has already been ruled upon, or the methodology to challenge the section has already been ruled upon by the Court of Appeal. And as I indicated, Your Honor, there has been absolutely no appeal from that decision. The second issue that we wish to address this afternoon, Your Honor, is the validity, as we have put it in our submission, in relation to Order 60. Much has been said, Your Honor, about the pronouncement in Eslin David's matter by our apex court. Your Honor, I first wish to ask this court, and I know this is a mature senior court, the entire judgment has to be read as a whole, to pick out or cherry pick certain parts, to misconstrue and base submissions on, Your Honor. I don't believe that this should be permitted. Your Honor, at paragraph 15 of the CCJ judgment, reference there is made to the decision of the Court of Appeal and the specific findings made by Justice Reynolds that Order 60 created a new election regime. Your Honor, it was in response to that the court made certain specific findings, that it was trite law. In fact, it was elementary, the court said, that an order, subsidiary legislation, could not amend the Constitution. The court went further to say that GECOM nor the Court of Appeal could trample on the exclusive jurisdiction of the High Court to hear these matters. Your Honor, those observations were in direct response to the decision by the Court of Appeal to read Order 60 in a particular way as amending the Constitution. Your Honor, Article 8 of the Constitution also speaks to that. What Article 8 says, Your Honor, is that in any event, even if a subsidiary legislation or another piece of legislation comes into conflict with the Constitution, it will be void to the extent of its inconsistency. Not void ab initio, but void to the extent of its inconsistency.
Now, she's making an interesting point here that if something is is if one aspect of a statute is deemed unconstitutional or inconsistent, then it doesn't completely vitiate or cancels the rest of it. And that's been ruled by the CCJ, and she's trying to make that point because the CEO and the APNU, they're trying to completely wipe out Order 60, and she's making an argument here, which is supported by law, which has precedence actually. All right, let's watch.
And Your Honor, it is this time honored principle which the apex court was simply endorsing. I wish to make a further point, Your Honor. GECOM at no stage intended or set out to usurp, trample, trespass, or somehow take upon itself the clear provisions of Article 163 of the Constitution. That was never the intention of Order 60. Order 60, the purpose, the aim of Order 60 was simply to produce a final credible count of the votes of the March 2020 elections. How was that to be done? That was to be done in a clear, transparent manner with all stakeholders present, with live streaming. Your Honor, a reading of David's judgment in the apex court shows clearly that Order 60 was endorsed by our highest court. The court references the procedure outlined in Order 60 and why that was necessary. That was necessary, Your Honor, because there were difficulties, there were controversies which visited the electoral process. And what the law says must happen. The very Constitution that my dear friend is relying on, 162.1 states clearly what GECOM must do when these issues arise. And it is out of that, Your Honor, that Section 22, therefore, becomes relevant. So GECOM, all GECOM did, Your Honor, was allow, or by virtue of Order 60, allow a credible recount of the votes to be done. GECOM did not invalidate any vote. GECOM doesn't have the capacity to do so. That is why we have the clear.
Now let's hear that very, very clearly. That GECOM does not have the capacity or the ability to invalidate any votes. All right, let's keep listening.
Exclusive jurisdiction of the High Court, Your Honor, to deal with those issues.
Might I just ask a question though, Ms. Kine? You said it was never the intention, but I'm understanding from the applicant and others who support the applicant's case is that even if that was not the intention, or it was not the intention of GECOM in relation to Order 60, that in actuality there has been a breach. So they might not have intended it, but there has been a breach. That's my understanding of their case.
Yes, that is what they're saying, Your Honor. But nowhere in that order is there any provision. I mean, I've read this order, and I know Your Honor has read it. There is any provision which establishes GECOM as the High Court to allow it to take evidence. It is not only an order would have to do that. We would have to amend the Constitution of this country to permit GECOM to undertake that kind of evidence base to resolve, to resolve disputes in this manner. GECOM does not have the capacity. In no more, I believe, Your Honor, almost three times in Ali and David's matter, the CCJ reinforced this principle that the chairman of GECOM was correct in her determination that GECOM could not and does not have the mechanism to resolve these disputes, that the disputes would have to be resolved. Well, I should not call them disputes, the allegations, because at this stage, Your Honor, they are still allegations. The allegations would have to be resolved by virtue of an election petition. The highest court has already said that. So I know, my dear friends, their arguments are premised on the notion that somehow Order 60 is bad in law simply because the GECOM deferred and GECOM indicated that it could not resolve these disputes in the manner in which they were acting, and that really this would have to be resolved by the High Court. Your Honor, when you look at Order 60, where GECOM says that the order will resolve, or the recount process, Your Honor, will resolve and produce a final credible count, Your Honor, that is the counting of the ballots between what happened, which resulted in the March 13 declaration, and the recount. It was to resolve that, not for GECOM to take upon itself to become the High Court. Certainly, Your Honor, because as the Apex Court said, this would trespass on the exclusive jurisdiction conferred on the High Court under Article 163(1)(b). And the CCJ so found, Your Honor, at paragraph 52 of its judgment. To say, therefore, Your Honor, even if a court, I wish to say, Your Honor, even if a court finds that that small portion of the order was unconstitutional, Your Honor, that does not affect the entire order.
Sorry, which small portion of the order,
No,
Ms.
our submission is that it is not unconstitutional. I'm saying, Your Honor, that even if my friends premise their argument on the fact that GECOM somehow by this order is supposed to become an election court, I'm saying that when the time arises during an election petition, even if a court so finds that a part of Order 60 or a portion of Order 60 was unconstitutional, that does not produce a finding, Your Honor, that the entire order is bad and void ab initio. That is what I'm saying. Because all Article 8 says that anything which conflicts with the Constitution would have to be void to the extent of its inconsistency. So even if we go down the road of my friend's arguments, this does not invalidate Order 60.
But I'm trying to understand what portion you would be referring to.
Well, Your Honor, that is not our submissions. I'm just trying to clarify this. Because when you look at Order 60, Your Honor, no part of Order 60 sets out to make GECOM an election court.
Now, this is made very clear by counsel that no part of Order 60 sets out to make GECOM an election court. So they can't throw votes out, bring votes in, say this is valid votes, all the rubbish you hear from APNU. GECOM can't do that. All right? Okay, keep listening.
The final credible count which the order speaks to, Your Honor, is in relation to the count which led to the March 13 declaration and the controversies which visited. And so, as our Apex Court say, to ensure that this new transparent process would produce a final credible count. And Your Honor, 38 and 39. In fact, even if we start from 37 of the CCJ's decision, 37, 38, 39, 40, the court specifically, Your Honor, considered the transparent, credible process which resulted from Order 60. In our submissions, Your Honor, we have stated the process which Order 60 adopted and what different officers as a result, were permitted to do as a result of that process. We rely, Your Honor, on those submissions. And we close, Your Honor, subject to the questions which the court may ask, if the court has any. We close with the fact, Your Honor, that, and our submissions bear this out, I've noticed that a number of the respondents they have also made this point. A number of these issues, I would say all of these issues, have already been litigated. They are just framed in a different manner, Your Honor. Neither can we just go with a contention that is a different party before the court. Your Honor, if we do that, if we say that because the party changes, you can come back with the same issue, our electoral process would never have finality. Because every time a court rules, a new party will come with an application. So, Your Honor, this is a simplistic view and manner to determine the issue of res judicata. Cannot rest on just that there is another party before the court. And I know, Your Honor, is a mature senior court. It has to do with what are the issues which are being ventilated. And I respectfully submit, Your Honor, that these issues, all of these issues, they have been ventilated either in Yulita Moore's matter or in Eslyn David's matter.
Good. Thank you very much, Ms. Kite. I just have a couple questions. I think Mr. Jeremy was making this distinction, and I had noted it, whether the Moore decision could be read narrowly to say, well, the court was really only considering the lawfulness of GECOM undertaking a recount supervised by another entity, to which we know CARICOM, as distinct from GECOM undertaking a recount, so that if the Moore decision is read very narrowly, is only speaking to the lawfulness of a recount, excuse me, supervised by CARICOM, as distinct from the lawfulness of a recount generally, that their pronouncements in relation to Section 22 and their pronouncements in relation to the recount being for any challenge to the recount being for an election petition would be, to use Mr. Jeremy's words, obiter, or not applicable to the case at bar.
Respectfully, Your Honor, I cannot agree with that narrow interpretation. When Yulita Moore, in her application, she was challenging the CARICOM supervised recount, and the declarations which she came for asked the court to order GECOM to accept the March 13th declarations, which is being asked for here also. May I just say that in passing? To order GECOM to accept the March 13 declarations. When the court, see, the finding of the court is what is relevant to you, Your Honor, because it is during that the court found that GECOM can conduct a recount. The court did not put any limits on the matter of that recount, except that GECOM could conduct it, and that GECOM, all that GECOM must do, GECOM must ensure that GECOM is not basically abdicating, ceding its functions to any other authority. So to now come to say that it was only in relation to that CARICOM recount, Your Honor, that is a very narrow and simplistic way to interpret the decision of the court.
And finally, either way, isn't the principle from Moore that if GECOM or the chairperson's decision can be reviewed by the court, that the chairperson GECOM's decisions can be reviewed by the court if it appears, either GECOM or the chair, they appear to have acted or be acting outside of their constitutional or statutory powers. Isn't more espousing a general principle that the court can exercise its supervisory jurisdiction?
Yes, please. That has been endorsed by Moore. The court said the only way that the court can intervene is if there seems to be, if GECOM is either acting in excessive jurisdiction, then of course the court can intervene in a supervisory manner. We have contended here, Your Honor, that when you take all the issues into consideration, that GECOM is not acting in excess of jurisdiction. Because all GECOM is doing is attempting to bring closure to the electoral process after a valid, endorsed, transparent process. So we have addressed that in our submissions. And we have stated that, yes, if there is excessive jurisdiction, but here in these circumstances, Your Honor, GECOM is not acting in excessive jurisdiction.
But then,
Now, here Boston is going to try to make an argument that the recount is legal and then the recount is not legal, you know, all in the same argument. So the first stage here is going to say the recount is okay. So watch.
if it is amending Section 84, then what act is it contravening?
No, if it amends 64 without replacing it, all it has done,
Boston, I'm sorry. If you say it amends, then it must replace it with something.
But
If it amends,
it has not replaced it. What it has done is to make Section 84 ineffectual, so GECOM can act unlawfully and recount votes that were deemed to be final. That is what it was doing.
Moments later.
so which
Because
do
Mr. Jeremy did not argue that alternative view.
okay? So which view are you really supporting? Because is it Mr. Jeremy's view or your alternative view? I mean, I have to get guidance from you. And Mr. Jeremy is saying I should accept his view. You were saying you began, unless I misheard you, you began your submissions by saying Section 22 is constitutional, because that's why I stopped you and I asked to make sure that I was making a correct note.
Alternatively, the fact that I'm arguing alternatively does not mean that Mr. Jeremy has not adopted that alternative position.
Oh my gosh.
Oh dear, Mr. Boston, I don't know if you can speak to Mr. Jeremy, but I will hear him later on. But I don't know that he adopted your alternative position, but be that as it may.